consider, because I want you to address it later. When we dealt with the development of common law, because of the debate, I suspect I might have taken you off track. But I really want you to state exactly what is the common law study in terms of the testing mighty solutions, and then what are the reasons and the rationale for the existing common law. And we dealt with the spirit report of the object, and we dealt with the indirect application in respect of the labor practices and deprivation of property. And then you will need, given that you seek a carve out, you're seeking a carve out of the common law as it pertains to everybody else. For employees, what would be the consequences of such proposed change to the common law? So that's mighty solutions. It says
yes.
That's the test. And of course, as you know, the caution has always been by the Constitutional Court. The court is to exercise a caution and deference when it comes to, if the Labour Relations Act must be amended, then that's a prerogative for the legislature to the extent that you seek a carve out in the context of the employment relationship, or the employment context, and there is that option. That's if what the legislature thinks is appropriate. But because you're seeking this carve out, not a general development and change in the common law, but to be raised in the context of an unfair practice on the one hand.
Yes.
Like we do with those issues with extended. Thank you. But I'm sorry for the interlude, but it's my fault because I've taken him off track earlier.
My Lord, may I commence my argument under three headings? First one, to consider arbitration in South African law, because that really gives us the parameters of what we may inquire into today. Secondly, I'd like to consider the factual basis underpinning the application. What are the facts at hand? Because it seems to me before we start asking a constitutional or inviting a constitutional debate, one must decide what the facts are you're dealing with. And thirdly, some preliminary points, condemnation, acquiescence, and those preliminary ones, which really cut across the whole debate. May I then start off with arbitration in South African law? And I'm going to spend some time on it, but what I'm basically going to conclude in my submission is that we are in this point in time in our law dealing with three types of review. One is a review under Section 33 of the Constitution. That's a Paja review, and that doesn't apply to arbitrations, we know that. The second type of review we deal with is one under the Labour Relations Act, which has in Section 145 incorporated the same test as we find in the Arbitration Act in Section 33, but, says the Constitutional Court, that is infused by constitutional values, the value of fairness, for example, which carves out in labour law, in labour jurisprudence, a second category of review. And then the third category, the only one relevant to us, is the one under Section 33 of the Arbitration Act. And I wish to consider what is a gross irregularity, and when can a gross irregularity lead not to a review, it's not called a review in the Arbitration Act, but to setting aside the award. That's really the test here. And we will illustrate to your Lordship that gross irregularity has to lead to a trial which is not fair before you can trigger it. But in order to chart that course through the heads, may I ask your attention for our heads in paragraph 37, page 16.
Page 30.
Page 16, paragraph 37. The Doyle reference.
But I just indicate that I've printed your heads out in a bigger font.
Yes.
So your page numbers doesn't correspond.
I see.
So
shall I refer to the paragraph?
Just
numbers?
to the paragraph.
37, I'll do that. It says the principle that where the legal issue is left for the decision of the functionary, any complaint about his decision must be directed at the method and not the result, we say is of impeccable vintage, and we quote NSCJ. In fact, that quote is carried on in paragraph 78 of the same heads, where the learned Chief Justice says the following in that quote, and it's important as a starting point for our debate. Paragraph 78, there's a long quote there. Yet in this case, it is a mistake of law alone which is relied upon as constituting gross irregularity. There is neither an allegation nor suggestion that the magistrate, his attention having been drawn to section 37, deliberately refused to apply his mind to it or to consider it. The position of the section means that the applicant contends is that the magistrate either honestly misinterpreted or completely overlooked. That's our case. All four arbitrators overlooked the constitutional point. In either event, it would not, I'm afraid, be the first occasion on which a court of law has misread a statutory provision or overlooked one not brought to its attention at the trial. I may impose that's true for an arbitration also, of course. Whichever supposition were the correct one, the result would be, still assuming the correctness of the applicant's interpretation, an unfortunate error of law which, but for the special prohibition of the statute, would afford good ground for an appeal. But there would be no gross irregularity in the proceedings, and therefore no justification for a review. We've said that is of historical value, but that's the law today. If your Lordship considers Tel Cordia, which is in our file, in their bundle at page 16, that's very much still the law today. Tel Cordia, page 16, paragraph 69. Passage read by my learned friend, and so often us colleagues read the same passage and we give a different meaning to it. This is one of those. 69, page 297 of the reported decision.
paragraph again, please.
69, my lord. It's on page manuscript 16 of my learned friend's heads. Bundle. Harms J.A. Errors of law can no doubt lead to a gross irregularities in the conduct of the proceedings. Tel Cordia posed the example where an arbitrator, because of a misunderstanding of the Audi principle, refuses to hear the one party. Although in such a case the error of law gives rise to the irregularity, the reviewable irregularity would be the refusal to hear that party, and not the error of law. Likewise, an error of law may lead an arbitrator to exceed his powers or misconceive the nature of the inquiry and his duties connected therewith. And then the important one in 85, paragraph 85 of the same judgment. I pick it up at the foot of the bundle, page 17. In all these cases, the complaint was directed at the method. No, 85, I'm sorry, it's page 18, foot of page 18.
18.
Page 18 of the bundle,
Yes.
paragraph 85.
Yes.
The fact that the arbitrator may have either misinterpreted the agreement, failed to apply South African law correctly, or had regard to inadmissible evidence does not mean that he misconceived the nature of the inquiry or his duties in connection therewith. It only means that he erred in the performance of his duties. An arbitrator has the right to be wrong on the merits of the case, and it is a perversion of language and logic to label mistakes of this kind as a misconception of the nature of the inquiry. To argue Jap Moko again, it was argued before the first arbitrator, it was argued before the appeal tribunal. Both of them said, doesn't assist you, Mr. Roux. We apply it and it's against you on the onus. They may be wrong on that. I don't think they are wrong, but they may be wrong on that. You can't review under Section 33 as an irregularity because it didn't affect the process of the arbitration. Mr. Roux had all the ability to do what he wanted to do in the arbitration. He decided to plead very parsimoniously, not to tell us what his defenses were, running us into a 6-week trial. Then right at the death, pick up a point on damages, wanted to call expert evidence. That's the debate I'll come to. But there was nothing unfair in that process. If the arbitrators got Jap Moko wrong, if they placed an onus where they shouldn't have placed the onus, the parties have agreed to appoint them to be the arbiters of that question, not a court. And as long as they honestly applied their minds to it, they might even have overlooked it, says the books. You can't call that an irregularity if you can't establish that it didn't lead to a fair trial. Now, I'll show your Lordship, it's stated by Mr. Roux in these proceedings that he does not contend that the trial was not fair. Now, that's correct. Clearly, the trial was a fair trial.
Mr. Burke, as I understand, as I put to Mr. Duval, the error of law must manifest itself in a procedural irregularity
Yes.
in the proceedings.
Outside of Audi Alteram and jurisdiction, it's very difficult to envisage that, but I thought of this example. If there's a dispute where a lady sues for goods sold and delivered, and the defense is, you cannot sue on contract because you're a lady, and ladies don't have handelingsbevoegdheid, and they decide to refer that to arbitration, and the arbitrator says, this is a good offense. She's a woman, she can't sue on contract, and I make an award, I dismiss her claim. She's got a reviewable irregularity. Obviously, she's got handelingsbevoegdheid. Obviously, she can contract. But the question is not whether the arbitrator got the law wrong, or whether the defendant got the law wrong. She didn't have a fair trial. Her case was not heard because the arbitrator said she can't be heard, she can't speak, she doesn't have a voice. But apart from that rather absurd example, it's very difficult to envisage that. And I'll show you the books, where the books say, Reagan says, even in a constitutional matter, the Constitution, if anything, entrenches arbitration. It makes it more difficult to set it aside. Because under the Constitution, we must protect arbitrations. You shouldn't give new equipment to people to agree to arbitrate, to appeal the arbitration, and then to come and say, surprise, surprise, I have a new point to raise in a court of law. Well, then we go around in circles. But I'm running ahead of myself. I'm still in our heads on this issue, and if I may ask your attention next, dealing with arbitration and the right to set aside, May I ask your attention for paragraph 39 of our heads? This is where O'Regan J. dealt with the effect of the Constitution on arbitration setting aside. 39. The Constitutional Court in Lefuno has reaffirmed the principle that deference to party autonomy should be shown when litigants have agreed to the adjudication of their disputes by arbitration rather than through courts. Regarding the raising of constitutional points, O'Regan, she was then acting Deputy Chief Justice, held ordinarily the question whether a particular arbitration award should be set aside, turning as it must on the precise terms of the arbitration agreement which regulated it, will not raise a constitutional issue of sufficient substance to warrant being entertained by the court. So, my lord, in this case, there was no constitutional issue triggered on the real facts, my second subject, and I'll come to that. But let me assume for the moment that the facts were as the applicant says they were, and assume that that might have triggered a constitutional debate. Assume they proved that the university had benefits. They raised it on the pleadings first, and then in the trial they addressed it, and then it was proved. Assume all of that. And the arbitrators decided on these facts, we're not going to extend the common law remedy. Common law remedy, Jap Moko, sounds to us to be right, and we're going to apply that. You're stuck with it. Court's not going to interfere. The court will only interfere if the court says on that issue the applicant didn't have a fair trial. But he says he had a fair trial. He accepts that. He accepts that he tried to show the benefit to the university. And in fact, I'll read you the passages, my lord, where my learned friend's predecessor, Mr. Fagan, says, I want to consider whether I can lead this expert, because not having raised it on the pleadings, I can't lead it. So I want to go back to Cape Town and decide whether I must amend and then lead the evidence to show what ephemeral benefit the University of Stellenbosch gleaned from sponsoring house dances and having golf balls to donate it. They came back and they said, we're not going to go ahead. Now, there's no suggestion of unfairness here. There is no suggestion that at the end of the day, in dealing with the law, somehow Mr. Roux was presented to argue the law property, or to lead the evidence he wanted to lead, or could lead, I must say. Not wanted to lead, could lead. Because he can only lead it if it's an issue on the pleadings. And, my lord, I was in the trial. Throughout the trial, we put down the beacon. Whenever there was a suggestion that there was going to be evidence adduced on benefit, we said, watch it. We will object because you didn't raise that. In fact, Mr. Roux, you have denied that the money was expended. It was that bad. He not only denied that it went into the 4 accounts, he denied it was expended. What we were then doing is, we called an expert out of London, and he had 8 exhibits, R1 to R8. You read about that in the awards, my lord. And for a long time, we showed how every round went from account 260 into the 4 accounts and out from there, out of the university. We showed it. Long evidence. No questions asked. No questions asked on R1 to R8. Now the argument today is there was an irregularity on onus. We don't get to onus. Onus is the domain of the arbitrator. We get to the fundamental question which my learned friend, with great respect, couldn't answer, placed from the bench. What was the irregularity? What was the unfairness in the trial? Well, of course there was no unfairness. We complained bitterly about how the pleadings unfolded, how we were put up to enormous expense to prove what we thought should have been admitted, but that might be unfair to us, not to Mr. Roux. And there was nothing unfair.
Could they have amended?
Beg pardon?
Could they have applied for an amendment?
Well, that's why they stood down right at the end to go to Cape Town to consider the amendment.
Because they did say, we reserve, or we will consider even applying for an amendment if that's...
Well, in that note handed up yesterday to your Lordship. I'm interrupting myself now, but on page 3, there's a helpful quote in this context. Page 3, and I'll come back to this. The second last window from the foot of the page. Advocate Fagan at the hearing before initial arbitrator says, "The objection is because we have merely denied the allegation of damages, and we haven't expanded on that. That precludes us from leading evidence as to who, what value this rugby club initiative and so on might have had for the university." They knew they couldn't lead the evidence because they haven't pleaded it. They've denied the expenditure. So it's a bit of a chutzpah today to come and say, but we had an unfair trial because you didn't prove how we spend the money, as if we would know about the Haze Dance. That year, PSO had 100,000 rand donation to their Haze Dance. When I asked Mr. Roux on that, and I said, did the other universities have that flashy Haze Dance? No, he said, because they didn't have access to the funds, which was a true answer. But where's the unfairness in the trial? I'm asked rhetorically. But I'm busy considering the review.
The business of the university, the Haze Dance.
I would hope not. Oh, we very much do it there, but it's not the business of the university. As it isn't the business of the university to sponsor 4 balls at the golf club. It may be great for the golf club. It may even be great for the manufacturer of the golf ball. But how that gets to... And my lord, this example was given before of the forklift. Now, on the monies dissipated here, 35 million rand. Mr. Roux could have bought about 70 forklifts, and he could have pleaded. He could have said to the university, but you had a benefit. I bought 70 forklifts for you. I would have loved to cross-examine on that. I would really have loved to cross-examine on that. But of course he didn't tell me what he did. I had to prove what he didn't, then he didn't question my expert. And then our heads, and this is really a passage I must just conclude on this one, our heads, paragraphs 50 to 52. We say, Roux's complaint must be that there was a gross irregularity in the conduct of the arbitration and the appeal tribunal, resulting in him not having a fair trial. That's as we read the case law. The founding affidavit, however, does not suggest any irregularity in the conduct of the arbitration or the appeal. It contains mostly legal argument. The complaint is aimed at the outcome, not the proceedings. And then 52, importantly. Significantly, in Roux's replying affidavit, he states that the question is not whether the hearing was fair, but whether there was a gross irregularity. Now, that's wrong in law. But he's making the concession. He says, I don't complain about a fair trial, and for once I don't cross swords with him. I agree with that. Caedet quaestio, there's no case left on the books as I read the cases.
It doesn't make sense, the answer, because
You can't talk about a gross irregularity that doesn't lead to unfairness.
No, indeed. My Lord, I'm so reassured that this is old law that I've found a case which may be of assistance to you, which is not in our heads. May I hand it up to your Lordship and give my learned friends copies? It's an old Transvaal decision, 1938, by a bench comprising Greenberg and Schreiner. And my Lord, at that judgment at 560, may I pick that up just about a third down, page 560. It is His Lordship Mr. Justice Greenberg, the then Judge President, speaking, and he says, "The law as stated in Ellis v. Morgan has been accepted in the subsequent cases, and the passage which had been quoted from that case shows that it is not merely a high-handed or arbitrary conduct which is described as a gross irregularity. Behavior which is perfectly well-intentioned and bona fide, though mistaken, may come under that description. The crucial question is whether it prevented a fair trial on the issue. If it did prevent a fair trial on the issues, then it will amount to a gross irregularity. Patent irregularities have this effect, and if from the magistrate's reasons it appear that his mind was not in a state to enable him to try the case fairly, this will amount to a latent gross irregularity. If, on the other hand, he merely comes to a wrong decision owing to his having made a mistake on a point of law in relation to the merits, this does not amount to gross irregularity. In matters relating to the merits, the magistrate may err by taking a wrong one of several possible views, or he may err by mistaking or misunderstanding the point in issue. In the latter case, it may be said that he is in some sense failing to address his mind to the true point to be decided and therefore failing to afford the parties a fair trial. But that's not necessarily the case. Where the point relates only to the merits of the case, it would be straining the language to describe it as a gross irregularity. That's repeated very many decades later by Harms J.A. in Telcordia. If the arbitrators here got the onus wrong, and they put an onus on the applicant and not on my client, the parties chose the arbitrators to take that decision. If you then say, but it's not an unfair trial, well, you can't come under Section 33. Don't have a right to set aside them, to object to the award being made in order of court. And may I just conclude on this? We are really not dealing with an appeal. And my learned friends, in our respectful submission, treat this as an appeal. Not only Jap Moko, but if you have a look in their heads, my lord, to paragraph 41.1. They deal with the award by the appeal tribunal. 41, they say the appeal tribunal, then 41.1, held that the finding that Mr. Roux had allocated funds beyond the reach of the university in the sense that it could no longer apply the funds for purposes that could and would have been authorized by its council inevitably resulted in the conclusion that the university's patrimony was reduced. That was the finding. They say, in our respectful submission, this finding begs the question as to what the loss is. What is the loss if the university's funds are spent on one legitimate cause rather than the other? Well, that's appealing it. You can't appeal it. You can't second guess the entity you've asked to decide that, not in a review of an arbitration, not of an appeal comprising these three arbitrators. 41.2, the same. They say the arbitration tribunal held that the university, quote, was deprived as a result of Mr. Roux's conduct of the entirety of the funds had he had reallocated and were subsequently misapplied. But they don't agree with that. They say in our respectful submission it is safe to assume that even in the absence of Mr. Roux's conduct, the university would have been deprived of the funds when it expended same on its own legitimate causes, as opposed to the legitimate causes identified by Mr. Roux. It's quite a startling proposition, quite startling, to say that there's nothing wrong here because the money he misdirected into his own cost or cost points and then dissipated into the rugby club and then used for whatever. It's not really a loss because in any event the university would have spent it. They had the money. They might well have spent it. They would have built a hostel with it. Or they would have sponsored empowerment bursaries. Yes, that they wouldn't have done what was done here. There's no suggestion of this argument being raised by either of the arbitrators. You shouldn't have raised it before the appeal tribunal. You would have had a curt answer to that. But this was never raised. You can't now re-argue the case, my lord. This is not an appeal. So,
I understand, do they raise this in to the extent that they
seek to make the point that loss was not proved as what they call the overall onus.
no, but the finding of both courts, both arbitrations acquis, was that my client bore the onus to prove the loss. That it held. And it says it established that loss by R1 to R8, which was not challenged. Then we argued, and we say akin to a theft. If you steal my money and you go and buy a motor car with it, it's not a defense to the theft. You may be able to say, I needed the car and you registered it in my name, and therefore you didn't have to buy the car, so there was no loss. But you must raise that. You can't steal my money and then go and have a dance with it and then say to me, but you would have had another dance and therefore I didn't steal the money. And we say by analogy, it's the same as Jap Moko. That's why the books say, and we read the SCA to say, if you allege a benefit, just allege it. Just allege it and we can inquire. Remember, under Hosmet, the arbitrators are bound by the pleadings. They can't probe outside of the pleadings. Now, if Mr. Roux denies that the money had been spent, a fortiori, he never said it was spent, but it was spent for your benefit. He considered doing that and decided not to do it. So we really go around in circles. We go into a debate which is a non-debate in this case. There is no mention of a benefit. The first arbitrator then held, by analogy to the theft example, and we quoted learned authority from academia, from the SCA, to say that's the position in theft. If you allege that the stolen money was used for the benefit of the kid, say that. We say it must be the same here. Both tribunals said we agree with that. They may be wrong on that. We might have been wrong in those submissions, but those are findings of law. You can't appeal that. You can't appeal it to this court, except if you can show there wasn't a fair trial. And I'm now repeating myself. The statement is not that there wasn't a fair trial. So on the test of review, and I'm using the word incorrectly, on the test of setting aside an award, base one is not arrived at. They don't get there.
So can I just test this? So when the arbitrators make the finding that there is that there is a loss, but
Yes.
they do not take into account the benefit, because the benefit, the arbitrator said, was the onus of the
Yes.
applicant to have pleaded and proved. In the absence of the applicant pleaded and proving, the arbitrators then find that is the loss
Yes.
at the end of the determination. And they say that's almost circuitous, because then it means that if the arbitrators believe that wasn't, the onus was on the university, on the respondent, the applicant to have proved, then the arbitrators are simply arriving at a position as to what the university said was its loss.
No, they didn't argue like that. They did. There was no onus raised by Mr. Roux because he didn't raise it. The only onus was to prove damages on the university. That they've proved. They've led evidence for weeks on that. Proved it from the pocket into the dance hall. All throwing flew. No cross-examination on that. There was no onus arising for Mr. Roux because he never raised it on the plea. He said, I didn't spend the money. Well, that was false, we know. So it wasn't as if they had to consider different onuses. They said, on these facts, these are general damages, not special damages. Well, I think it's clearly general damages. It's flown naturally from the misapplication. That's the one attack on them. And the second attack is, I'll come to the attacks here.
So
Onus.
The argument is that the nature of the inquiry was to determine ultimately the damages
Yes.
arising from breach. First, there
From
would
the
have been a breach contract, and then there would be the damages. The determination of the damages is onuses where they lie.
Yes.
They say there was an overall onus on the.
If I understand the point sought to be made was that other than the transfers and we found to be unauthorized, therefore unlawful, there was no other basis for a finding of unlawfulness of the expenditure, such as his own personal use.
No, with respect not. There was a finding. The finding was one in law, and it was analogous to the finding in theft. To say, if you remove my control of my funds, I've lost it. If you remove the privilege I have to direct where my monies go, I've suffered a loss. Don't have to prove anything more, I've lost it. You may now come and say, you've built a hostel for me in my name, and I have a benefit. Then we go into that whole debate. That doesn't arise. But this is a finding that I've suffered the loss. I don't need anything more. That's a finding in law based on facts, both binding on you, my lord. Both correct with respect. I've argued it twice, successfully twice. I think that is the law. That's the common law. It must be so, my lord. Let's try to test this by way of an example. My financial manager steals 10,000 rand from my petty cash. And he decides to do something with it. He doesn't tell me what. But he decides to do something with it. I sue him. I say, I have a contract with you. You may not steal. That's implicit in my service contract with you. You removed the money from my petty cash. I want 10,000 back. There's no answer to that claim. He may come back and say, I used the 10,000 to pay for the painting of our workshop, which you had to pay, but you didn't pay, so that's another place. Erase that. But that cause of action is a simple one. You took money from my petty cash and I don't have it anymore. That's the finding here. Now says my learned friend, but Roux wouldn't know what he did with it. The university must know, really. The university must know that this was spent on a haze dance. They would be very surprised to hear that. Or this was sponsoring the golf club at Stellenbosch Golf. They would be very surprised to hear that. They discovered it after he had left. After he had carefully closed the accounts. As he left, he closed them. No more leakage. And there where there was 40,000 left, he said to Mr. De Beer, there's some sparries there. Use that, Papoiki. That's the end of the joyride. He doesn't know what he did. He knew exactly what he did. When I told him what he did through KPMG, he didn't challenge that. It took a lot of time for me to work that out, but I did it.
I understood that you say that the university knew that these expenditures would be
Options have been given.
No, they wouldn't know that. How they wouldn't know about. That's why they discovered it a year after he had left. Quite by accident, they got into something, and the evidence was the financial manager discovered this, and he nearly had a heart attack. He said, "There's something wrong here. There's an opening balance and a closing balance which must be identical, and they're not. There's trouble here, and there's a ruffle in the Daverhawk." They appoint the auditors, and eventually they discovered what has gone on here. And when they discovered it, when the penny dropped, they said, this is FFB 122, whatever. Only place where this leak can be, because there's no audit trail. Arbitrators found he did it surreptitiously. He didn't tell anybody. Kept it quiet, and then he spent 35 million rand. So, my lord, this whole debate that he didn't get the money into his own pocket, that was floated in the newspapers at the time. It's not a good in law. And the suggestion today that we didn't prove that we didn't get a benefit is factually wrong. It's not the law, it wasn't pleaded, and the facts weren't found to that effect. My Lord, my third subject I'd like to address are some in limine submissions. We call them in limine because although they should have been raised in the beginning, the merits of the review really comes into some of them, and that's why we had to address that first. The first one is, your Lordship has the power to grant condonation here. And that condonation is given under Section 38 of the Arbitration Act, which says the court may, on good cause shown, extend any period of time fixed by or under this Act, whether such period has expired or not. And the relevant period here is a 6 weeks period, which you'll find in 33 sub 2 of that Act. An application pursuant to this section shall be made within 6 weeks after the publication of the award. Now, my Lord, the award by the single arbitrator was made 14 months before the application to set aside was brought. 14 months instead of 6 weeks. If you don't set aside that award, it's unhelpful to set aside the appeal award because you're going to lose your 37 million rand in the first one. Both grant 37 million rand. What's the explanation for not having brought the application to set aside in that one? The application, or the reason you find, my Lord, you find it in 35. Page 35. Let me just get that. It is the record, page 35, in our heads, footnote 118, page 35, 118. Yes, no, it's 35. Just bear a moment with me, let me just see that I have this right. Yeah, our heads, page 35, paragraph 90.1. It's helpful there because it gives your Lordship the reference, and I'm going to take you to the reference now. Yeah. My Lord, we say in our heads, in paragraph 90.1, the condonation cannot be granted because the application is brought more than 14 months after the initial award without any explanation for the delay. The explanation in the replying affidavit has no merit. Now, that is footnote 117. Your Lordship will find that explanation on page 318 of the record. This is the only defense to the 14 months delay on setting aside the first award. And at page 318, paragraph 10, we raise it in the answering affidavit. We say you're badly out of time. You haven't even addressed it in your founding paper. And they say, paragraph 10 on page 318. The university contends that there is no explanation for the delay for a period of 14 months after the initial arbitration award was delivered, but the reason for this delay is obvious, that it didn't need to be spelled out. The parties agreed in their arbitration agreement to an automatic right of appeal against the initial award, and therefore the appeal option had to be exhausted before the review could be instituted. That's wrong for the following reasons. The parties agreed the appeal in the arbitration. The review is granted to the applicant under the Arbitration Act. The appeal is to arbitrators to be agreed upon. The review can only be done by a court of law. Arbitrators can't review. Thirdly, you don't appeal a gross irregularity. You're wasting time to do that. If there's a gross irregularity under Section 33, it means you didn't have a fair trial and the thing can't go on. There's nothing to appeal. It's a review. In fact, there was no objection on this score when the matter was appealed. They didn't know about this review ground. The review ground they discovered somewhere in January or February 2022 for the first time. So it's just not right to suggest that they had to pursue the appeal. They never thought about it because they didn't know about this constitutional point. So, my Lord, there's no explanation why the first award was not reviewed within 6 weeks of December 2021 when it was given.
Other than they misconstrued.
Other than they
misconstrued.
Yes,
that they should have rather sought a review at that stage
yes,
than appeal.
yes.
Can Mr. Roux be blamed for that?
Well, they don't take the point. They don't say it was a misunderstanding or a fault by the lawyers. They say we read the contract wrong.
But it appears that they were seriously misconstrued on that point.
But that's Mr. Roux's problem. Then Mr. Roux must come and say, I couldn't afford counsel. I only had 2 heavyweight silks at the Cape Bar. And somehow we all missed it. That's not his case. His case is read the arbitration agreement. We say, we'll take you by a word. We'll read it. That refers to a consensual right to appeal. If your objection now is one of a material irregularity, then you've wasted everybody's time with the appeal. Then we've wasted 3 arbitrators and millions of rands in cost in the appeal. It was all aborted. It should have been set aside for an irregularity. It's fundamental, my Lord. They just can't come home.
I can accept that the legal teams might have got it wrong. And probably did get it wrong on that issue. But should Mr. Roux be penalized for that?
But he teaches the lawyers. I don't accept for a moment they got it wrong. I don't think there is a constitutional point here.
That's a separate question.
No, it's the same question. If he honestly look at the time he got the Shelter Douglas Award and read it, I don't think there was a constitutional point. What was it on those facts? I don't see it. That's why I submit there is no constitutional point here. And I'll deal with the deprivation of property and the Labour Relations Act. Those are no constitutional points. And to the extent that he suggested that the constitutional point is to develop the common law, but the Constitutional Court says to us, His Lordship, Ms. Reagan says, you develop the common law depending on the facts. And if you have new facts and you apply the common law and you must develop the common law, you must develop it with reference to the facts. My learned friends say, no, forget about the facts here. You must develop the common law here, absent of the facts. You must develop it in vacuo, as a principle. That's not the law. You can't develop the common law in a theoretical sentence. You must develop it with reference to the facts at hand. Taking your lordship to the facts at hand. There's no constitutional point here. He misapplied the funds. He then used this for his own benefit, which we proved. He then didn't suggest that there was any benefit to us, and we quantified it, and he didn't challenge the quantification. There's no constitutional point.
You know, constitutional points are regularly taken long after a quo proceedings, and that's comments made in the Constitutional Court about should have raised it then. So the Constitutional Court accepts that at times litigants don't raise these constitutional
Yes.
points
No, I understand
early
that.
enough.
I understand that.
And they should have been raised early on. And you should have sought a development early on. And the Constitutional Court goes on to deal with the constitutional point. And Carmichael then sent it back because it was so important and so egregious.
But that wasn't a egregious point. That was the point where the lady is not allowed to sue because she's a woman. It's egregious, of course. Here, your lordship is told by the applicant, who takes all these points, I do not contend for not a fair trial. There's no constitutional point there. Because once he had a fair trial, even if there were a constitutional point, it is, as Reagan J says, it won't prevent the award from being made in order of court. She says if it's not a substantive constitutional point, the woman without handelingsbevoegdheid, I'm not going to interview. She says, in fact, the Constitution has made arbitration awards more sacrosanct than in the past. She says that's in other jurisdictions we look at, that's an international trend. Otherwise you have this. You run for a 7-year vintage trial, and once you want to make it an award, take a constitutional point. My Lord, that's the first point, that delay was not explained. There's no suggestion that Mr. Roux was misadvised by his lawyers at the time.
I suspect if
he was advised by this legal team, they would have said, let's take the constitutional point.
Yeah. Yeah, I don't want to be flippant, but he's the man who says he can't afford lawyers. Only university can afford lawyers. So, I mean, if we count heads of silk, he's in the majority. My Lord, you can't... in the end, then you must say that, my Lord. I keep fighting windmills here. His case is not. I had silks before, they missed the point. I got new silks, they got the point. No, he says the contrary. He says the Arbitration Act prevented me from taking this on review. That's his point.
Yes, but I also understand him to say that it was his... Mr. Erasmus, that his attorney was.
Yes.
He was the one who thought of the constitutional point.
No.
And he had to go and then get expert advice.
But he was always the attorney. He was the attorney from the inception.
So if something had occurred to him other than briefing new counsel who raised it for the first time.
Yeah.
So Mr. Erasmus had somewhere in his pocket a constitutional point.
He doesn't tell us that.
But we know in January he says that the constitutional point, which I assume he must have arrived at, then gets sent to the experts for an opinion.
My Lord, that's why I say I'm at a disadvantage. I don't know the facts, because the answer does not come back in reply to say, Mr. Erasmus then in January thought of this point. And I'm so sorry, I should have done it, and I asked for condonation. My first set missed this completely. My new set now picked up the point, and that's why I'm late, 14 months. I asked for condonation. They say I don't need condonation. It's under my arbitration agreement. They say it's obvious. My Lord, I'm not going to spend time. We've addressed the delay of 12 weeks, and we've done it in the heads. I'm not going to regurgitate that. What I want to say is that being on holiday is not a good reason for condemnation. Acquiescence.
Well, except that in any other circumstances, the court would consider it benevolently.
I'm in your Lordship's hands on that.
You know, the explanation is given: illness, holiday, COVID, and that. You know, I'm not inclined to gong somebody out on that reason.
No, I understand that. I'll say as my learned friend, I can't take that further. That's your decision, my Lord. Acquiescence. My Lord. Our heads, page 35, paragraph 90.2, I should say. And if your Lordship at the same time, please have a look in our authorities bundle in VENMOP. That you'll find in that bundle from page 147 onward. It's my head's paragraph 90.2.
Yes, thank you.
Your Lordship was shown the correspondence which exchanged. There was a clear acceptance that the monies were due. But what I want to refer you to, just before I look at the case, I want to show you the replying affidavit, page 323. And I do it in the context of acquiescence. Of course, my argument is at the time when Mr. Roux tried to pay his judgment to my client, he had no idea of a constitutional point. It was long before he saw that point. Page 323, his attorney is speaking. My learned friend referred very briefly to it, but can I ask your Lordship to just read this with me? This comes in reply, paragraph 25.2. The attorney says, even before the award of the appeal tribunal became public, I was informed by a reliable source on a confidential basis that the strategy of the applicants' detractors, we're still in an anonymous country, we don't know who's speaking to whom, who the detractors are, would be, if the appeal went against him, immediately move to sequestrate him. SA Rugby, in terms of its constitution, which we don't know, would then be obliged to terminate the applicant's employment. My Lord, this is all inadmissible. It's quite improper to say this. It's double hearsay, unidentified. It is no explanation why the letters were exchanged, except to say there was acquiescence in the award and clear acquiescence. He phones and he says, can I talk with you on how to comply with the award? No sequestration, no threats by anonymous people, nothing of the kind. Now, can I ask you to have a look at VENPROP, which is on all fours with this case. And your Lordship will see in paragraph 3, that's in our manuscript page 149, but I'm going to refer to the paragraphs in the judgment itself. That's page 149. First paragraph is paragraph 3 in VENMOP. On 9 January 2014, Cleverlad's attorneys addressed a letter to VENMOP's attorneys demanding payment of the amount in terms of the award. In February 2014, not having received a response, Cleveland made application to the High Court for the award to be made in order of court. On 19 February, VENMOP's attorneys replied to the letter of demand by way of a letter in which VENMOP offered to make immediate payment of the sum of 50,000 with further payments of 10,000 per month and an undertaking to review the offer every 12 months, clearly accepting that it was to be paid as Mr. Roux did here. 4. On 16 April 2014, 1 day shy of the 18 weeks after the publication of the award, VENMOP and the second applicant, the mother, brought the present application to set aside the award on the ground that the arbitrator had committed a gross irregularity in the conduct of the proceedings. Then the learner just picks it up in 20. It's on our manuscript page 152, 20 at the foot of the page. And counsel were at idem on the test as we are here, 3 lines from the foot of that page. First is the existence of the dispute. Secondly is that the statement is part of negotiations for the settlement or compromise. And then 21. The letter was written in response to a demand for payment of the amount of the award at a time when an application had been launched for the enforcement of the award and there existed no challenge to the award. Other than the dispute as to the authenticity of the signature, which had been resolved by the arbitrator's award, there was no dispute in existence. The letter could not be said to be a statement of negotiations to settle a dispute. In its terms, the letter merely attempted to obtain an extension of time period by offering to satisfy the amount of the award in installments. Here, Mr. Erasmus wrote to say, I want to arrange with you how to comply with the award. No qualification, no precondition to that. And then, over the page, paragraph 26. Although the doctrine of preemption had its genesis in relation to appeals, it has been extended to applications for rescission of default judgment. Although there appears to be no precedent for peremption in the context of an application to set aside an arbitration award, there appears to be no reason, either in policy or principle, not to apply the doctrine of peremption to such right. I don't think our learned friends cross swords with that principle being applied to arbitrations. And then just finally, 27. At the time the letter was written, the award had not been made an order of court and there was no writ capable of execution. The writing of the letter and the offer to satisfy the award, albeit on terms more favourable to Venmop, were not something Venmop was required or compelled to do. In my view, the only reasonable inference and conclusion to be drawn from the dispatch of the letter is that Venmop had acquiesced in the award. And if your Lordship reads those 3 letters, you will with respect have no doubt that at that stage Mr. Roux acquiesced in the award. Therefore we say there was a peremption and he can't now be heard to apply for setting aside the awards. My Lord, and the third point in limine I wish to make is this. These awards have already been made in order of this court. Against Mr. De Beer, he didn't oppose. It went into the opposed motion roll, and after this application had been filed, the application to set aside the awards, this court made the award, both awards against Mr. De Beer, orders of the court. Now, can your Lordship imagine you refusing our application and the awards against Mr. De Beer has been made an order of court? You'll have 2 conflicting decisions on the same awards in this court. And that you will only do if you're confident that that judge was clearly wrong in having made the awards, make them an order of court.
That's assuming
Both of the judges were aware of what was taking place in respect of the other, and that the judge dealing with Mr. De Beer's matter had sight of all of these papers and the benefit of argument. You see, it really doesn't help to say because it was made against De Beer by another judge, these papers were already filed. I don't know whether the judge had even considered these papers.
Neither do I. But in timing, these were filed before the application to set aside was brought.
Yes.
And the only point I make is there's something incongruous in the fact that against De Beer the awards are made orders of court and the sheriff will go and execute. Against Mr. Roux, he now says, don't make the award an order of court. Set it aside. It's a very strange set of
strange,
affairs.
but it's
very strange.
It's no more than strange. I can't put it.
So we are in the
We
Midsummer
can't
Night's
put it,
Dream, so we
can't
shouldn't
put it
be
higher than
surprised.
that.
Well, My Lord, then dealing with the relief being claimed by our learned friends, we say condemnation shouldn't be granted. The Section 33(1)(b) should be refused.
Mr. Berger, you said you're going to talk to the court about those two constitutional.
Yes, I
issues.
am. Let me do that now. My Lord, the two constitutional points. Let me try to short-circuit that. Our head's paragraph 77, developing the common law. My Lord, we say in paragraph 77, the issue raised in the second line of attack was not raised in the arbitration or on appeal. It's not contended that in making the award and order of court, any unconstitutional laws will be enforced. That's cool ideas. This is not a cool ideas case, where the applicant says, if you, court, make this award and order of court, you'll be in conflict with a statute of the land, which says you can't give an award for building costs to a builder who's not registered with its regulating authority. It's not that type of a case. So what is developing the common law? They say it's the following. There is no reason why they, referring to the arbitrators, should not also be permitted and required to develop it to ensure it complies with the Constitution. We say he didn't plead that. That's really a different point. That's developing the common law. Your Lordship asked me for the two constitutional principles addressed. That's at page 33, paragraph 81. Arbitrary deprivation of property.
Okay, just before we get there,
Yes.
I had a lengthy debate with Mr. Bishop about what is the standard that this court should consider about whether it ought to have been considered by the arbitrators, the development of the common law. The heads of argument talks about, well, is a plausible constitutional issue. And he accepts that the bar is still low on plausibility, but he then refers to the cas Michel, and in the one end where it's egregious, and two where it is intimated or a constitutional issue is implicated. It's not very clear on that, but we'll get to that. Do you want to address me on that issue?
Yes.
About?
My submission is that before your Lordship will consider a constitutional argument, your Lordship will ask the prior question, was the trial a fair trial or not? If that question is answered in the affirmative, and that your Lordship will have to decide on a balance of probabilities, caetat quaestio. It was a fair trial, you don't have to consider a constitutional point. O'Regan says, a constitutional point in arbitration, if not material, meaning if he didn't lead to an unfair trial, you can ignore. So you don't embark on that inquiry. If you then conclude, which you can't here, but if you conclude there was no fair trial here, then you will ask, my Lord, what was the constitutional point and what are the facts underlying that point? And there are no facts for a constitutional point. On my learned friends' facts that the university benefited, whether that calls for an extension of the common law is, and I say this with great respect, decided by the parties to be within the domain of the arbitrators, not the court. So you won't embark on that. Your pure inquiry is, was there a fair trial? That's all. And if that is answered in the affirmative, this plausible debate doesn't arise. The constitutional debate doesn't arise. And that's what the Constitutional Court says. I've really now put the imprimatur on the sacrosanct nature of an arbitration award. in the context of a review under Section 33(1)(b). I hope that answers the question, because it's not a direct answer, but I'm posing a prior question. And once that question is answered in a certain way, with respect, your Lordship's question doesn't arise. You can't second guess the arbitrators on whether to expand the common law or not. If they decide we will not expand it, the parties chose them to decide that. If that results in an unfair trial, that they say women do not have contractual capacity, of course you'll intervene. But that's not because they made an error in law, that's because there was no fair trial. And there I go back to NSCJ via Harms JA, via O'Regan acting deputy judge. That's the line, that's the law.
Even so.
Yes.
Even so.
The imperative of the Constitution is that when applying common law, there's a positive obligation on a court or even on the arbitrators
Absolutely.
to have developed common law.
Absolutely. 39(2), that says.
You accept that?
Yes, I
Even
accept
on the arbitrators?
The arbitrators must do that.
Yeah.
Yes.
And if the arbitrators don't do it?
No, with respect. If they don't do it correctly, they're entitled to make a mistake in law.
Yes.
That's said 1906. They're entitled to get the law wrong.
Yes.
As long as it doesn't result in an unfair trial. They may decide not to extend the common law. They may say Jap Moko is good. And your Lordship will say, look, it's the SCA, but I don't like it. I think it should be changed. You can't do that, my Lord. You haven't been asked to do that by the parties. They've given that decision to the arbitrators. They only come in the third category of setting aside in our law, Section 33(1)(b). That's the narrow one. That's why I started my debate with that. They are the arbitrators. They can be like the magistrate. He gets the interpretation wrong. He misses the section in the Act. Fine, he's entitled to make a law. NSCJ says it does happen. Well, you should see 2023. It does happen. Can't intervene.
Yes. But except that they go further with regards to the issue of an irregularity, a gross irregularity. They say there is a gross irregularity, which then manifests itself by virtue of the arbitrator not having appreciated the nature of the proceedings.
No, they can't say that. They must say that it resulted in not a fair trial. And they say, we don't say that.
Yeah.
That's theoretically they add it. It is meaningless. The only way from an irregularity to make it effective is to say there's no fair trial.
Yes.
They go on oath to say, we don't say I didn't have a fair trial. I think that's the end of the debate. The arbitrators, if I'm wrong on everything, if the facts were as my learned friends have the facts, and the arbitrators didn't consider it, and they should have considered it, and they considered it and they say we will not expand the common law, or we will expand the common law, I can't appeal that and they can't appeal that. We've decided they must decide that.
Much of the
Otherwise,
case,
we're going to be where we are today, where we re-argue the case now.
yeah,
We really re-argue the merits. What does Jap Moko say? The appeal award was not correct on this. The judge got the onus wrong. You can't have, that's an appeal of an appeal. That's not what Section 33(1)(b) is about. It's not even a labor or law debate, because there the Constitution say, the Constitutional Court says that review is infused by the Constitution. So fairness comes in, and says the Constitutional Court, that means at times you must look at the merits. You can't look at the merits here. This is not a labor relations LRA
LRA.
debate. This is a Section 33 debate. It's It's much narrower. And the Constitutional Court is jealous to show that. I must hand up to your Lordship another very helpful article by His Lordship Mr. Justice Brandt. In 2014, he gives a lecture in Stellenbosch, and he considers arbitration awards and the judicial review of arbitration awards. Can I just give you two passages, my Lord, at 249 of that lecture? First, unnumbered paragraph from the top. It is remarkable that the advantages of arbitration are truly today as they were when Foote described them in his day. He wrote that arbitration was often resorted to for the termination of a suit and the avoidance of formal trial, as an alternative to the heavy expenses of lawsuits, the din of legal proceedings, their harassing labours and pernicious delays, and finally the burdensome and weary waiting on the uncertainty of law. His comments bring another age-old truth into relief. The primary and essential value of arbitration lies in the very fact that it exists as a way of avoiding a formal trial. Indeed, the advantages of arbitration are unfailingly framed in comparison to the disadvantages of litigation and centre on the ways in which arbitration offers means of circumventing these. It stands to reason, then, that these advantages are diminished or even largely destroyed if the courts should adopt an overkeen approach to intervene in arbitration awards. This is so because an interventionist approach by the courts is likely to encourage losing parties to feel that the arbitrator's decision is wrong, as losing parties mostly do, to take their chances with the court, and if the arbitration becomes a mere prelude to judicial review, its essential virtue is lost. There's also the argument that it is wrong in principle for the courts to meddle in disputes that the parties themselves clearly chose to withdraw from them. And then he makes the point right towards the end of what I've submitted is the three types of arbitration now, review now at page 259. I'm not going to read it due to time constraints, but your Lordship will see he refers to Sidumo Rustenburg Platinum Mines in the middle of page 259, and from there he concludes at the end of 259. After all this, it seems that gross irregularity in the conduct of proceedings now bears two meanings in consensual or private arbitrations on the one hand and the LRA arbitrations on the other, while in statutory arbitrations outside the field of the LRA the position is governed by section 6 of the Parliament. So we really have three types of review, and I'm contending for the first type, the section 33(1)b type review. Irregularity coupled with unfairness.
Submissions made in the heads of argument by the applicant relates to the issue of fairness. That's repeatedly stated, the fairness of the proceedings.
Well, they accept the fairness on the affidavits.
And that's the incongruity.
Well, it's not incongruent. They can't argue away from it then. Once the deponent accepts that they had a fair trial, supported by the facts in this case, your Lordship will not read the heads of argument to the contrary to say this is unfair. It's also a LRA debate. Fairness doesn't come into this debate. Your Lordship is not asked to say whether what was done was fair. The question is a more nuanced one. Did they have a fair trial? That they say they had. They clearly had. We don't even have to debate that. Clearly had a fair trial.
Sorry, you have 2 minutes just to deal with your two constitutional
I'm
challenges.
sorry, I'm so late.
I'm sorry, I'm as I did with the applicants.
I wouldn't have it any other way, my Lord.
Waylaid you.
My Lord, the first point is in our heads paragraph 81, and I've quoted the argument because I don't understand it. 81 says this is arbitrary deprivation of property. This is the citation. Money is property. A law that compels a person to pay that money to another is a deprivation. The question turns on whether the common law, which permits the deprivation of Mr. Roux's property, is arbitrary. I don't understand any sentence of that. All I want to observe is the following. I am not debating deprivation of Mr. Roux's property. I'm claiming 37 million rand, which he surreptitiously took my control away and spent it at his own election. That's what this case is about. So I've never asked for his property. I just want to be put in the position where I would have been had he not reached his property. Today there is a suggestion that there's a risk argument coming in. Your Lordship should be careful of the risk. But I think that was said in the context of employment law. Now, your Lordship will remember that the SCA had said that in order to decide unfair dismissal, you must lean in favor of the employer because he's the party who employs. It's his decision to dismiss. So if you consider unfair dismissal, you must give him a bit of a head start. The Constitutional Court said, no, you can't do that. You must treat them equally. That's the very point of the LRA. And they've definitively held that whether there's unfairness in dismissal, you must look at both sides. We don't deal with the dismissal. Mr. Roux resigned, he became CEO of another entity. By the time that we litigated, he was a high flyer in the business world. He wasn't my employee. So, and briefing, looking at his teams, he had no problem in defending or pursuing. The second line was the unfair labour practice that we deal with, paragraph 87 and following. Yeah, my learned friends referred in their heads to the Pretorius case. They haven't now included it in their bundle. They haven't argued it today, so I really don't think that's helpful. That's a case where there was a promise made to an employee which was then breached. No promises made to Mr. Roux.
It was argued by Mr. Bishop, is that right? With regard,
May I just say we've
it was the exception which was taken.
Yes, it was an exception stage. But the facts are just so distinguishable that it's not really a persistence here. My Lord, we might have overstated something in our heads, which I must just qualify. Towards the end of our heads, we have dealt with the relief sought by our learned friends.
Sorry, before you get to the relief,
Yes.
the issue that I raised with Mr. Bishop is that really what they're seeking here with the development of the common law in the context of employment law is a carve-out of the common law. So it would apply to everybody else. They're not saying that the development of the common law takes place generally whenever somebody unauthorized allocations and expenditure of somebody else's money, but only in employment law. So they're seeking a carve-out in the respect of employment law
No, they can't.
in the common law.
They bring an application under the Arbitration Act, under 33(1)(b). They are bound by that section. They do not come under the LRA. That's a different test. Fairness comes into that test. This case has got nothing to do with fairness. If they carve out the common law here, and if they convince your Lordship to decide what the common law is here, that'll be the common law of the land. That will bind everybody.
Well,
That's quite a startling proposition. You will overrule and develop Jap Moko, find that not only were the arbitrators wrong, the SCA was wrong, and the parties in the end, that's one of the points, the parties chose not to ask the court that question. They said that question will be decided by arbitrators. So at worst, you'll refer it back to arbitrators. You can't decide that, my lord, and I say that with the greatest respect.
No,
the arbitration agreement says that's for the arbitrators to decide.
The issue here is that they're seeking a carve-out specifically for the employment relationship with regard to the issue of onus. That's really what they want. How does that impact on everybody else, on the Jap Moko situation? So it only would apply the common law would apply in the Jap Moko situation, but in respect of the employment, where it's an employment relationship, there's a special dispensation.
With respect, that submission by our learned friends run away with the chronology. If your lordship were to hold that there should have been a consideration of extending the common law, then you must refer it back to the arbitrators to consider that. You can't do that. That's the point we make. If I could just get my glasses, I apologize. This is the point we make. In paragraph 95 of our heads, and this is where I really wanted to go to, it answers this question of your lordship, I hope. 95. This is followed. The first is setting aside, we say they're not entitled to that. 95. This is followed by a prayer that the court replace both awards with an order that the university's claim be dismissed. You can't do that, my lord. There is no application under section 32, and the parties have agreed that that decision is for the arbitrators to make. Then 96. In paragraph 3 of the notice of motion, and by way of an alternative request, Roux seeks the setting aside of the award of the appeal tribunal and remitting the matter to a freshly constituted appeal tribunal for consideration. The last sentence is too widely stated because 33(4) of the Arbitration Act envisages such a process. 33(4) says, if the award is set aside, the dispute shall, at the request of either party, be submitted to a new arbitration tribunal constituted in the manner directed by the court. So presumably what that means is if your lordship sets aside the award, you'll ask my learned friends and us, what do we do now? And we hopefully will agree to go to one arbitrator or to 3 arbitrators. And if we quibble, your lordship may well have the discretion to say, I rule that 3 arbitrators will hear it and I will send it back to the 3 agreed, or for some reason they can't decide it, I'll appoint 3 new ones. I don't think we'll get there, but we've overstated that sentence. 33(4) does give you an opportunity to cut the Gordian knot if that becomes necessary. My lord, those are really the submissions on behalf of the university. If there's any outstanding question, I'm happy to try to do that.
Thank you, Mr. Berger.
Thank you, my lord.
Mr. Dwar.
Thank you, my lord. Do you find the interaction productive? I hope.
Always is. Always
Lord,
is.
Lord, may I just say that, of course, we did allege in the founding papers that there was a denial of a fair hearing. And your lordship will find that at page 20, paragraph 28, where the deponent says the initial arbitrator in the appeal tribunal committed a gross irregularity because they misconceived the nature of the inquiry and the proceedings, with the result that the applicant was denied a fair hearing. So it's not so that he accepts that he got a fair hearing, he says the opposite.
And how do you deal with the point that he planned?
Whoever drafted that language should get a deduction because it's totally circular. It says it's a gross irregularity, but it doesn't deny a fair trial. If you look at it from so if we can stick to the founding
This is funny.
But you see, but they go further. They say just look at the procedure, is there fairness?
Yes, you will get back to that one.
Okay.
But certainly from the paper's point of view, that's not the position as stated in the reply. Lord, I don't want to go into the Grant article and so on, but the question of fairness is much closer between LRA and Section 33 reviews than one thinks, or that was submitted, because of Lufunu Mapuli and the judgment of Oregon Jail, it's in their bundle. If I can take you there to page 33, in our letter friends bundle, page 128, sorry my lord, it's page 128. Sorry,
77.
Right in the day, 109. Page 109, there's two numbering systems here, so that's why 109 on the right-hand side and 128 on the left-hand side. But she in Lufunu at paragraph 20 to 221, at the bottom of that paragraph, your lordship will see, after all of this, she says, the arbitration agreement should thus be interpreted unless its terms expressly suggest otherwise, on the basis that the parties intended the arbitration proceedings to be conducted fairly. So it's the same, there is an element of fairness that must be read into every arbitration proceeding unless it's excluded. Lord, I will come to the main point which I'll state at the end, just on a couple of other issues. With respect to our learned friends, it can never be that the judgment granted in favor of De Beer is somehow binding. It's not raised judicata, it's not issue estoppel, the dispute wasn't determined. It's on a different cause of action, in a way it's a different case. So whatever your lordship, that does not seem to us to be a good point. My lord, and similarly, the issue of delay with respect cannot be assessed on the basis that we should have come to court with a review because the appeal tribunal, and the reason for this is that the initial arbitrator had the same powers as the High Court, and the appeal tribunal the same powers as the SCA. And we know from all of these cases that we've gone through that the very point that we want to assert and what should have been decided was in Jap Moko, Palabora, Stocks. All of those decisions were granted by the SCA in respect of the approach of the trial court. So it's not a review, it's an appeal. Apart from the fact that most of the appeal to the appeal tribunal concerned the merits of whether there was an irregular expenditure. But to the extent that the onus was raised again, it's no different from Jap Moko in the High Court, Jap Moko in the SCA, where ultimately the court said, well, I'm going to overrule the point on the onus, and therefore you don't pay anything, Minister. And the second thing is that arbitrators on appeal in this case, of course, did decide all of these points. Is it suggested that they committed some irregularity by doing so? No. These points can be raised on appeal. Half of it concerned anyway something else, and it's logical if the parties agree that they will first go to exhaust that remedy of the SCA before going on review.
But we never agreed on that. First go to the SCA.
And then, or first go on appeal in the arbitration and then on review. The review was open to them after the initial arbitrator made the award.
Yes,
because the appeal tribunal doesn't deal with the issue of the gross irregularity. If there was one raised at that stage, there would be no need for an appeal.
Yes. My lord, may I put it this way? Perhaps one could have gone, or accepted what your lordship said, you could have gone from the initial arbitrator's award straight to the High Court and seek a review of that. But when explaining the delay, because there were aspects of the merits of the case that also had to be decided, can our client really be blamed for saying, let me exhaust the appeal remedy first? I can get a decision in my favor on the merits, for example, there, on whether there was irregular expenditure at all. I can get the Jap Moko decision. Initial arbitrator, you didn't get the owner's right, so therefore I'm going to interfere and overturn. I can get all of that why should I now go to the High Court, which is a limited review, before I've exhausted that remedy? That's more or less what we say in explaining the delay. Lord, if I can then, sorry.
You see, Mr. Roux says it's obvious. It's obvious why we went first on appeal and now come on review. That's simply bad advice to you. And should that bad advice be held against him?
Bad advice in the sense that he should have gone to the High Court, my Lord.
Yes.
Lord,
Or he could have, and he could have disposed of the proceedings right there and then,
yes,
rather than go on appeal. And if you don't get it on appeal, keep at the back of your mind that you still have a review, because the review first and foremost would look at the initial arbitrator's conduct in the proceedings, not so much the appeal.
yes. But except, my Lord, we would submit that it was...
All I'm attempting to do here is to be benevolent to you and say, if it's the lawyer's fault, should Mr. Roux be held responsible for
Yes,
it?
that as well.
That's all.
Thank you, my Lord. I now need to get to the two main issues, peremption, and I'm not going to take your Lordship to one passage. With respect to our learned friends, they had so much confidence in this point that they deal with it in one subparagraph with their heads, where they simply say, here, Quies, no references, no debate, and our learned friend today argued in our papers, which is entitled to. But my Lord, if one looks at the Venn mop, which they rely on, there are two problems with that case, which is described, I think it was stated that it's on all fours. But Venn mop, my Lord, doesn't apply the correct test. Of course, not the fault of the judge there, because the correct test was set out in SARS versus CCMA sometime after Venn mop. So one can't really assess Venn mop because it doesn't go to the high level that Mogoeng required, which is not a shred of doubt, as you would say, my Lord. Nothing. There must be not any doubt. So legally, the wrong test was applied in Venn mop. Factually, it's very different. And here I would like to refer your Lordship to paragraph 3 of the judgment in Venn mop. But now, it's late in the day and I don't have the reference here, but I will find it fairly quickly. It's in their bundle, Venn mop, of course, my Lord, and it's at paragraph 3 is at page 149. Let's look at what happened there factually. Factually, the first sentence perhaps not that relevant, and then on 19 February 2014, Venn mop's attorneys replied to the letter of demand. Firstly, replied to a letter of demand by way of a letter in which Venn mop offered to make immediate payment of the sum of 50,000 with further payments of 10,000 rand per month and an undertaking. So it was an offer of specific of the payment plan. It was setting out, here's my payment plan. Whereas our submission is that the letters written by Mr. Erasmus is open to the interpretation that he wishes to have a meeting to discuss an option which he may be able to do. Lord, that was it for the other points. The main is...
The Arbitration thing is something that Venn mop is wrong.
Too low.
Should have been the biblical injunction in, say that biting my tongue.
Yes.
Yeah, in Psalms.
Yes.
Okay.
And now for the main, and I don't want to break things down and refer to documents now, because really, my Lord, the debate was fruitful, And we would like to contend for the following. Legally, from a legal point of view, we would say that if Mr. Bishop is right, then there's a plausible case for the development of the common law to reverse the onus at that point about who should prove benefits. But even my part, which is the application of Jap Moko, even on that part, we would say legally, in the employment relationship, you meet the first hurdle by showing it's in the course and scope of employment. You meet that hurdle because that must be assumed to have benefit, and then it switches around at that point. You meet it at that stage. I just want to, I'll go to the facts now, my lord. But that's what we contend for legally. It's not considered in Jap Moko. What is the situation in the employment relationship? Should it be enough to show, I'm an employee, I put an ad out there. Oh, I now realize it's not authorized. The university, or let's take somebody else, a bank, puts out advertisements all the time. But now one of these advertisements goes through unauthorized. Must I not just show that I acted in the course of furthering the business of that employer in order to switch the onus on what is it goes to, what does it mean, benefit? Does benefit mean in the employment relationship in the course of business? Or does benefit mean that that poor person who has placed that ad must go further and say, this is how it actually benefited the employer. Oh, you got so many new accounts that was opened. Can it ever be right, my lord, that you have to then go to show actual patrimonial gain or financial benefit? This is what we contend for. I'll go now as to the facts. But this is, it's the carve out that your lordship is talking about, or put to our limit, but that is exactly it. It's different. And why is that relationship different? It is because employees have to spend vast amount of money all the time.
But how onerous is it is simply to plead it and then to prove it?
It's not
and
onerous
you don't
at all.
have to, and you don't have to quantify it on Jap Moko.
No,
So it's not a great onus.
Yes, my lord. It's not a problem at all if it means I've got to show within the scope of business. It becomes a very impossible task for an employee if I've got to show benefit in terms of financial gain. That's the only thing we say. It's whether we have to show if the expenditure on Marty Rugby Club, must I show it is within the course of business, normale gang van zaken? Or must I show, but you actually, call an expert, that only if you establish financial benefit, actual financial improvement of the position of the university, then only does the owner switch to the quantification. It's simply that, it turns on what the word benefit means. And we say in the employment relationship, you can never, because you do, the bursaries, my lord.
But all you've got to do is to plead it.
If we had to, my lord.
You say, so you plead it, you get into the box and you say, well, it was for the benefit, the forklift was there for the benefit of the employer. Good. Now, what actual benefit? Let's quantify what that benefit is. What's the value of that forklift? Did you get it at a discount price, or did you pay more for it? It's not a great onus that is being placed.
Maybe it's wishful thinking, my lord, but I think, with respect, I think you're very close to what I'm saying. Because it is saying, I buy forklifts I buy equipment. I now made a mistake by, without authority, buying the second damn forklift. Sorry. But I did it. Now what? I must show that I'm the person that buy equipment for the university. I'm that person. And it does buy a forklift. It's not a Merc that I bought here or something for myself. It's happening. We do this all the time. At that point, it switches because it's presumed it's for the benefit of the employer. Otherwise, my lord,
Sorry, at which point does it switch? Because
as soon as
Jap Moko says, plead it, prove it. And if you aren't able to quantify it, then it's the plaintiff who's not proved his damages. Okay? So all you got to do is to plead it, get into the box, and prove it and say, make the affirmative that it's been for the benefit. I can't quantify it, or I've tried. My experts have tried, but the other side hasn't given me all the information. Then Jap Moko says, plaintiff, you've not proved it, because there's been no quantification. Now, how can there be an onerous burden, even in the employment context? You see, if you want to develop the common law in terms of the Constitution, you've got to have good reason to do so. There must be a reason to do so.
Which is a differential impact on fairness in that relationship.
And you must tell the court what is the reason that you want. It's not simply a relationship, but what is the relationship? The proving of damages it's not impacted by the relationship. If issues of dismissal and conditions of service, those are issues that underlie relationship issues in an employment contract. The proving of damages doesn't.
No, but the relationship is somewhat different because the employee is constantly asked to expend money on behalf of the employer in situations where the expenditure doesn't benefit the employee ever. So you don't you sit in this situation where you live precariously. I've got to sign off on expenditure all the time. But when it comes to an unauthorized expenditure, what is going to happen now to me? Am I going to be okay if I just say, this is my job, I made a mistake here, I signed the wrong thing, and now this forklift is here, whatever? Or must I now go and call an expert on how this has actually benefited the university? I'm just saying, if the situation is so, and we say that is so, that all we had to do is to copy their particulars of claim, because they alleged the expenditure there, and there was a lot of evidence about it. But if it was so that I can give your lordship just a reference where the appeal tribunal say, but the university pleaded the expenditure. Don't say it was just a reallocation. They pleaded what was spent on. If I had to photocopy that and say, see Annex A to my defense statement, that is it, and I say at the end, expended in the course of the university's business. If that's the full stop, then my lord, we're 100% on the same page, and the question is just whether the facts allow us to argue that that burden was in fact met. Otherwise, of course, it's
was in fact met in this matter.
Yes.
No. The burden wasn't met. Appeal tribunal found that.
Yes. Now.
So sorry, we can't change the facts now. Because now the argument changes completely.
No. Can I move on to?
Yes, but I'm just cautious that we don't change fundamentally and say, well,
okay.
The only issue is in fact.
May I approach the facts like this, my lord?
Yes.
Because your lordship had put it to my learned friend. What is it that you say? Didn't say it, of course, like that, my lord. But what is it that you say is not within the scope of the university business? What expenditure? What? Just give us an example. Okay? What our learned friend did is, and it's again, that's how the answering affidavit reads as well, we deny that it's in the universities, but they always go to one passage and one passage only, which is where the appeal tribunal talks about the dances and the golf balls and so on. But what they leave out, and when your lordship took it up with my learned friend, but where it ends up is that, and we know that part of the appeal tribunals now, it's been referred, maybe 10, 15 times, but we, for what it's worth, also summarized this on the last page of this thing. When our predecessors then said, just at page 7, the last box. But look here, you're talking about golf balls and house dances and what's the other thing? Beer tent and so on. But what I'm saying to you is that all of that is in die normale gang van die rugby club en sy uitgawes. What is the answer to that by the appeal tribunal? They come back to say, this overlooks, whether it in the normal course was legitimate isn't relevant. It overlooks that it was poisoned or infected by the allocation, and therefore, so it just goes back to that point all the time. It was to place subjectively beyond and all those debates, but there isn't an argument, nothing, that suggests that anything was outside the scope of the university's business. Nothing. So we say that in those circumstances, the facts are enough. It was put to them. And we tried to solicit an answer out of them in these proceedings as well. Of course we did. Because we 4 times, I'm stating, how many times can you see? Say it's in the university's business. My little, I took your lordship to it already, but it's page 5. Well, it starts at page 4. There's 1, 2, 3, 4. 4 boxes, where in the founding papers, we put it to them. It's in the university's scope of business. That's what we're contending for. We're saying the expenditure was in the university's scope of business. And time and again, sometimes it's not dealt with at all, sometimes it's a bold denial, sometimes they go back to the golf balls and the beer tent. But we know about that because that was pertinently an issue before the appeal tribunal, and then dealt with by saying that, no, wait a bit, it's, what was the wording? Whether it would be in the legitimate, in the ordinary course is not the point. The point is that there was a prior, yeah.
The appeal tribunal did not find that the expenditure was the cause of the university's business.
On the contrary.
My Lord, it was what we're saying. As we, can I just take a step back? As I stand here, there is, I don't want to say not a shred of doubt, but there is no doubt that everything was within the course of the university's business. Because we had put it to them in the founding affidavit 4 times. Each time we're getting a different response. When it was argued before the appeal tribunal that golf balls and all of these things were expended, they pertinently came back, the lawyers on our side, and saying, but that's in the ordinary course of the rugby club's business.
The appeal court make it finding?
Yes.
Where?
It says the only reason why I'm saying is illegitimate, and that passage, page 7 that I just read to your lordship.
Yes.
No.
They say it's not in the normale gang van die rugby club because the allocation was unlawful, and that has a knock-on effect. Nowhere does it say, but the university's rugby club cannot have a golf day, and it was never put to, that was not the case. And that's why we say that factually, and I mean, I think it's probably wrong to say common cause in our papers, but it is not disputed that, because otherwise they would have said the university doesn't give scholarships. The university doesn't give Bruggen scholarships, doesn't give rugby players scholarships, doesn't give any of the stuff that you spend the money on. My Lord, on the last leg, it is the law, it's the facts, The last leg does it translate into a gross irregularity, and it's got to go through the process and the hearing. And there all we say is that if it was so, that
Mr. Yes, can I just ask this for the last time? Where was the unfairness in the arbitration?
that is the last point indeed, my lord. It's law, facts, and then where does the unfairness come in? My lord, if it is so that in the employment relationship, I, as the employee in the case of unauthorized expenditure, bears the burden to do more than show in the course of business. If I've got to show financial benefit, it cannot be fair.
No.
Because I just don't have that. Sorry. No.
Because you don't have what?
Because I don't have the access and the means to show that this actually, I'm saying all that it's not unfair. It's not unfair if all I have to do is within the course of this business. This is my job. I always do this. Now I made a mistake. But it was calculated to benefit you. As soon as you say actual financial benefit, then we would submit the employee cannot be expected to meet that burden.
Why?
Because, my lord, let's take this case now. All of these expenses on the rugby club is ultimately there to enhance his reputation. But how do you show actual financial benefit?
Sorry, you're an expert.
Yes, my
But you
lord.
didn't call, so I'm assuming the expert had some great insights into the finances
Indeed.
of the university, or at
Indeed.
least they've asked for it. So you can't say you cannot show it. You have all the mechanisms under the rules to obtain the necessary
Decided not to show
information
it.
for your expert to opine on it.
The argument is slightly different, my lord. It is saying as a general principle of our law, once I, as an employee, show within the course of business, and we say factually this was done here, I know it's in dispute, then the onus switches. And it switches because it knows in that relationship, not our facts, but it knows in that relationship that it's unfair to request or to put the burden on the employee. It switches because the law recognizes it is inherently unfair to put an employee who per definition spends tons of money, not tons, let's not take it any further, my lord, but that's a submission. So it's not in the context of this case. If the owner switched, then of course the hearing couldn't be fair, because the university was then required to quantify whatever.
So when does that switch take place? After pleadings?
No, it's I guess always there.
Are you now accepting that firstly there was an onus on the employee to plead benefit? Accepting that?
Yes, but it complies with it by showing that it's in the course and scope of his business. Yes, it complies with that at that point. That's what benefit means.
So he's got to plead. So he's got to plead benefit.
No, you plead that you acted in the course and scope.
Now you got to,
of his business.
yes, but you got to plead that the benefit arose in the context. So now we know we've moved to great distances today when the acceptance is made as an acceptance to plead. But the law says more. It says you plead and you prove. So you get in, you say, when I made the expenditure, this is why I made the expenditure, and to the extent it's in the cause and scope, there is a benefit to you. I can't quantify it, I can't give you the numbers. Jap Moko says, then the employer or the plaintiff has to quantify. That's the law.
Yes.
That's the threshold. It's not.
But the carve-out, my lord, the carve-out will say you did enough in terms of Jap Moko to switch the onus when you show that it's in the course of your employer's business. That's all you need to do. And the facts of this case, they pleaded it.
Sorry,
And Jap Moko, my lord, sorry, my lord, just as a side,
Sorry.
in paragraph 25, your lordship will see, it doesn't talk about pleading only. It doesn't say that, look here, we've got to go home today because, you didn't photocopy their particulars and annex it to your statement. It says admitted, all pleaded and proven. So in a sense, what we're dealing with here is the admitted type of situation, and it was never in dispute. I know that the parties didn't think like that at the time, but it was never actually in dispute that the burden that should be placed on an employee was met.
No, that's
Lord,
not correct. That's not correct.
Mr. Duval, you must present the correct facts. I wasn't there.
Yeah.
And so I'm reliant on you to present correctly what happened in the arbitration.
That's just not correct, what my learned friend says. I'm sorry to interrupt.
Mr. Duval, then you can't make that submission if it's factually
But Lord, if my learned friend can explain why it's not correct, then I'm sorry, I'm sitting, but I was inviting you to get up, but I can't respond to something that says that I'm not correct.
No, my learned friend says it was common cause. What does he rely upon that? Because the whole case was fought on the basis that we didn't have any benefit. He then wanted to prove an expert to show the benefit, and he didn't do it. So I don't know what was common cause and where I find that reference.
Thank you. No, my Lord, it's just going back to the same thing. I'm sorry. I say that benefit in the employment relationship means something slightly different from in the ordinary contractual setting. I'm saying benefit simply requires me to say I was doing my job, I made a mistake, I was doing my job. That's all. And it's common cause, and I'm not going to go through this stuff again, that they haven't shown a single cent of money that was spent outside the scope of the university's business. If they wanted to say that yes, we accept that the money was spent outside the scope, but you bought rubbish and we suffered the loss. Sorry, I shouldn't say rubbish. You bought some stuff that is then it was for them. That's the argument, my lord. I don't think I've got anything else. So I didn't deal with cost, my lord. We're happy, your lordship, we've got enough. So cost will follow the result.
Yes,
we don't argue anything else.
Thank you. Mr. Bishop.
Thank you, Lord. And if I can begin with where I began, Rule 16A. I'm not sure which is more embarrassing, to not file a 16A notice or to forget that you filed a 16A notice, but the 16A notice was filed.
Oh, it was filed?
It was filed, it was put on the notice
good.
board. Do you have a copy? Do you have the copy?
Okay, it's just that it's adding through to all of these papers, so good.
Yes, so this is the unsigned copy, but we'll make sure
Okay.
that the proper stamped copy gets into the court file.
Thank you.
They have it.
Sorry, I haven't seen that.
Sorry. Yes, this is can I perhaps beg you to hand it up?
Thank you.
So that at least deals with that issue. At least we remembered. We remembered at the time and forgot that we remembered. My lord, if I can deal with your questions about Mighty Solutions.
Yes.
I don't want to retread the ground that Mr. Duval is looking over, because I think he has dealt with our position with regard to the first and second issues, which is what is the common law and what is the rationale for the common law. Sorry, my lord.
Yes, thank you.
So Mr. Duval had the debate with you about what in fact Jap Moko means in an employment context and what benefit means, whether benefit only means course and scope, spent in the course and scope of employment, or financial benefit from expenditure in the course and scope of employment. And the argument, Mr. Duval's argument, is that properly interpreted, Jap Moko means all you have to do is show it was or needs to be admitted, or you must plead and prove that it was in the course and scope of employment, and then the onus shifts. And what the arbitrators in the appeal tribunal found is that that's not enough, that what you have to show is actual benefit. And I think that if I can take, we've been there before, but if I can just take your lordship one more time to page 143.
Whilst you're dealing with it, what would be so special about that pleading? It's in the cause and scope. Because you still have to plead it, and you still have to prove it. That's what Jap Moko wants you to do.
One more, that's why I'd like to take you to page 143, if I
Yes.
of the record. Yes. 143 of the record. So this is the Appeal Tribunal's award, paragraph 29. So what it says, a component of Mr. Roux's response to the university's claim, albeit that it was not specifically pleaded, was that the US's funds in question had been legitimately expended from the 4 cost centres. In particular, he said that these expenses had occurred in the normale gang in the rugby club in sy uitgawes. So it was argued on behalf of Mr. Roux, not controverted by Mr. Lombard or KPMG. And then the finding, however, whether the expenditure of the said funds and the manner in which this had occurred would, in normal circumstances, have qualified as legitimate expenditure by the rugby club of its funds, overlooks the point that it was in any event by money that got into those cost centres from an unauthorised transfer. But what we're saying is it makes all the difference in the world whether it was legitimate expenditure or not. Because in the employment context, if it was legitimate expenditure, and the appeal tribunal records that was his argument, it says maybe he didn't specifically plead it, but doesn't knock him out on that basis. We say that was all the difference in the world, because if it was, it shifted the onus. And the appeal tribunal says it doesn't matter whether it was or not. And so the first part of the argument is they got it wrong. My part of the argument is if they were right about the common law, they should have changed the common law. Because for the reasons that I've debated with your lordship earlier, and Mr. Duval, I mean, it is unfair and arbitrary to require the employee to do more than show. Sorry, Lord?
Unfair and arbitrary.
Arbitrary under section 25(1), so it would be an arbitrary, it would lead to an arbitrary deprivation of property. In the sense that arbitrary is used in 25(1), which can require proportionality, it can under Opperman even require a consideration of less restrictive means. So it's not arbitrary in the high sense that it is sometimes used in legality inquiries, for example. So well, that's where the common law is, what the rationales for it are clear from Jap Moko. And then I've dealt with wide offences, spirit, purport, and objects, how the common law should be amended, and what the wider consequences of the development would be. Of course, my Lord, my primary submission is that you should remit this back to an arbitration tribunal, which my learned friend Mr. Berg accepted this court can do, for it to in fact engage in the development. So all this court would say is that the irregularity was failing to deal with the issue of development and whether development was necessary. Go back and do it. And then obviously that development would have no precedential effect, but it would resolve the dispute between the parties. My Lord, you also asked whether this should be dealt with through amendments to the Labour Relations Act. And our answer to that is that this claim was properly brought as a common law claim because that's where the right comes from. It's a common law right. And so it's not, employment relationships are not exclusively regulated by the LRA. They're regulated both by the LRA and common law. And when it's the common law part of it, then it's appropriate to develop the common law to deal with the issue if that's leading to an unfair labour practice. So it's the same, Pretorius, again, I know it's decided on exception, I know the facts are different, but again the question there was, well, can you have a pure unfair labour practice claim for this conduct? And the court said, well, maybe you can. It didn't, and it rejected the subsidiarity argument that you had to go through the LRA.
Well, you see, yes, and it's the caution in Carmichael is that courts are very cautious in the development of the common law.
Yes.
And it's a very rigorous process, starting off here, whether this court considers that there was plausible reason for it to have been raised firstly, or not.
Yes, well, that's why...
Because this court then sets a precedent for other reviews when it comes to plausibility of constitutional issues. And that's the caution that the Constitutional Court says to this court.
Yes.
Don't just give green lights to go and raise constitutional points or you should have raised constitutional points.
Yes.
And so there's a high responsibility on this court to make that decision about raising constitutional points of the nature that you seek to make. And the court says, constitutional court says, just be very careful. This is not, because it will impact on the law significantly.
I accept that more. It'll impact on the law of reviewability of arbitration decisions.
Yes.
Because it will create the scope. And I accept that. I accept this is a novel use of Section 33(1) and a novel argument for a gross irregularity. But I submit that it is a gross irregularity if it's one of those cases. And as I said earlier, my lord, plausibility is probably too low a standard. But there must be a class of cases where there's an arbitration between parties relying on the common law, and there's either a clear unconstitutionality or an issue that requires debate.
Clear.
Well, either that, or there must be a case where it's apparent on the facts of that case, given the way what QJ says is the necessary implication that there may need to be a development of this common law, and then the arbitrator must call
On the facts of the case.
yes on the facts. No, I
On the
accept it
facts
has.
of- on the facts of this case, it doesn't arise a constitution issue.
Well, my lord, but that's I think why I took you to this page 143, because our submission really is that it's about this question of if it's accepted that this was in the course and scope of his employment, and that then the onus, it's unfair then to require him to do anything more. It satisfied that onus, and then the university was required to do more to claim the money back from him. Not to say they can't claim money, but to show how much they're entitled to.
So you now say it's unfair.
Yes, well, that's always been the argument, my lord, that if the arbitrators got the common law right, got Jap Moko right,
Yes.
in the employment context, that it is unfair.
But that's not what your client has said. He said, I got a fair hearing.
Well, my lord, I don't think you can read that statement in the reply. You've got to read it with what Mr. Duval took you to in the founding affidavit.
Yes, he took me there, we're all aware of that. But he
Yes.
said, I'm not claiming I didn't get a fair hearing in this matter.
But my lord,
And that's the end of it.
no, I don't believe it is, because
Why?
you've got to read that with what he says, his grounds of review in the founding affidavit. And so this is what Mr. Berger's argument was. Mr. Berger's argument on the constitutional points was, if you had a fair hearing, kaidit kwaiskia. End of it. It doesn't matter what your constitutional point is. You could be Ms. Carmichael in an arbitration, and tough luck for you. And if Ms. Carmichael had been in arbitration and she'd come to this court on review, this court would have said, well, were you given Audi? Yes, you were. Sorry, bad luck for you. That's Mr. Berger's argument.
No, I didn't understand the argument to be as simplistic as that.
That's how I understood it, my lord. He said, because there was nothing wrong with the process. And what our argument is that failure to consider it is itself a gross irregularity that renders it unfair. Because as I understood, maybe I misunderstood Mr. Berger, but
Yes.
what I understood him to be saying was, you can't make constitutional arguments about the merits of the common law and say the arbitrators failed to develop the common law. You can only make arguments about the fairness of the hearing. And what our submission is, sorry, my lord.
I think he took us through the whole context of 33,
Yes.
right up to the Constitutional Court.
Yes, my lord, and I accept the funo and fufuli that you,
That's the law.
yes, but what the law doesn't say, what that case doesn't say, is that when you agree to arbitration, you waive all your other constitutional rights.
No, of course not.
Of course not, exactly, it doesn't. And so if your other constitutional rights are implicated by the application of the common law in this arbitration, the arbitrators must deal with it. And if they don't deal with it, if they don't do what Carmichael said in paragraph 39, which is, there might be circumstances where a court, an arbitrator, my word, is obliged to raise the matter on its own and require full argument from the parties. If the arbitrator doesn't do that, it commits a gross irregularity that denies the person the fair hearing. And there's another point, and this goes to something that Mr. Brunt, former Justice Brunt, says in the very useful article Mr. Berger hands up. So he's reading to you from page 249, and he didn't read the last paragraph, which says, on the other hand, courts cannot distance themselves completely from the arbitration process. The paradox intrinsic to arbitration is that it requires the force and assistance of the very institution from which it seeks to escape. This is so because the courts and ultimately the executive stand in the background as enforcers of the arbitrator's award. The arbitrator may not himself assume the power to attach an execution of his award, for example. For this to occur, the court must declare the award enforceable, at which time it assumes the status of a court order. However, because the court is requested to uphold and enforce arbitration awards as orders of the court, it is duty-bound to satisfy itself that its functions are not towards unjust ends. It has long been understood that the role of the courts in approving or rejecting arbitration awards does not affect only the party to the particular dispute, but concerns the administration of justice generally. And so if we're talking about the application of a common law that this court is going to enforce, that may be unconstitutional, that gets to exactly what Justice Brunt is talking about. And so there needs to be a protection to ensure that whether arbitrators improperly overlook serious constitutional concerns, that a court can say, hold on, there's a real constitutional risk.
So you elevate implausible now to a serious constitutional concern.
My Lord, I can't point your Lordship to a test which says exactly what it is, because this is novel terrain. I've accepted that, my Lord.
Yeah,
and I've accepted...
You've told me that this is plausible. It's plausible. So we're dealing with it, you know. And I said it when I read this, unlike in Car Michel, it jumps at you. It doesn't jump at me. We're slow as, even you yourself said, just simply pleading.
Well,
how can that require a development of the Constitution?
My Lord, there's two parts to the argument. The first part is, if it is one that jumps at you, if it is one of those cases, we accept there are that category of cases where the court can say, no, arbitrator, there was a gross irregularity because you didn't consider it. I can send it back. Accept that in principle. Then the question is, well, is that one of those cases? Is this one of those cases which requires the court to do that? And Your Lordship, I don't want to rehash the terrain we covered earlier. Mr. Deval covered it with you again. We submitted is such a case because of the potential risk and abuse for an employee. But if this court is of the view that it's not...
Risk and abuse?
Sorry, no, the potential risk for...
And abuse?
Sorry, abuse is the wrong one, my Lord.
Please.
It is late in the day, I apologize.
No, it is, but I mean, we can't shift arguments because it's late in the day.
Sorry, my Lord. It was a slip of the tongue. The potential unfairness, the risk of unfairness to the employee. And if this court concludes that this is not such a case, then it must dismiss the application.
Yes.
But there is a category of cases like that, which would require the court to act in that way. Mr. Deval points out that he can still win his part of the case. Mr. Deval points out that he may still win his part of the case. That they're not, the constitutional, the first irregularity is entirely separate from the second irregularity based on the constitutional argument. My Lord, unless you have further questions with my submissions.
Thank you. Mr. Berger, just in fairness, is there anything that you've been misrepresented on in the argument in the reply?
Yes, I don't want to object. My learned friends weren't at the trial, so I accept that they may have a different perception of it. I wasn't sure what the course and scope was relating to. My learned friend, Mr. Deval, referred to the course and scope of the universities as business. My learned friend, Mr. Bishop, refers to the course and scope of the employment. Can I just say, the suggestion that Mr. Roux acted in the course and scope of his employment, surreptitiously taking money from the reserve, not leaving an audit trail, slipping it over 10 years out of the university, putting the university to proof through R1 to R8 how that money was dissipated, to suggest that it might have been common cause that he acted within the course and scope of his employment, we do not agree with. That wasn't common cause, it was hotly contested, and when we were put to the trouble of proving how it was spent, there was no cross-examination to it. So, my Lord, there was very little common cause in this case, except that Roux didn't plead his version. That was common cause.
can I accept that the arbitrators and the position was that the expenditure was not necessarily in the course of the university's business?
That's what they held. My learned friends in fairness read that. That's the page 143 of the Appeal Tribunal Thirty, where they say there is this theme from Mr. Roux that he didn't do anything wrong, he was just doing what he was. They say, however, whether the expenditure of the funds in the manner in which had occurred in normal circumstances has qualified as legitimate expenses by the rugby club overlooks. And then they say the allocation of the funds to the 4 centres that ultimately ended up in the funds of the rugby club had not been budgeted or authorised. These funds could thus not have been legitimately applied. To suggest that what he did was within the course and scope of his employment is not correct. He slipped it out. That's why we had the whole legal argument that if you take my control of my funds away from me, I've lost it. We were upheld on the law on that. So, my lord, I find it just difficult to argue with the facts keep shifting, and you can't have a constitutional debate without a factual substructure. But I don't want to re-argue.
The last thing, it's Mr. Duval and Mr. Bishop saying that the 44 comment about, we're not saying this is fair, this was just, it's all about gross irregularity. That's inconsistent with the earlier paragraphs in the founding papers.
Yes, well, at the end of the day, we are bound by what we're told by the applicant. It's difficult enough to pin him down. But we read the papers in this that you have a founding affidavit and later in time you have a replying affidavit. So we assume the version we must work on is the replying affidavit. The replying affidavit says we had a fair trial. We look at the facts and we say obviously that's right. There was a fair trial, that was a debate of earlier today. For my learned friends now to say no, but that's not right. You must go back in history to the founding affidavit, and that is really the challenge. That was not the challenge in the arbitration before Sholto Douglas SC. That was not the challenge before the appeal tribunal. In fact, in the appeal tribunal, there was these murmurs to say to the appeal tribunal, watch it for a jurisdictional point on HOSMED. And the chairman says, give me a note on what that point is, because I don't see it. They gave him a note. It had nothing to do with this. Then they write us a letter, the award comes out, and they lose it, and they say, how do we pay? We really want to talk, congratulations. Now they come and say, well, we didn't have a fair trial. Well, my lord, at the end you must choose your battlefield and then fight on it. You can't keep changing the goalpost, then I'm at a loss.
Good. So the Rule 16, capital A, that's been resolved. Thank you. You've seen the Rule 16, capital A?
Yes, we don't take a point on that.
Good. And that seems to, people have been given notice. All that's left for me to say, it's late in the day. To everybody, thank you very much for engaging with the court. Mr. Duval, Mr. Bishop, sometimes he gets a bit robust, but that's the nature of trying to understand where we are in the lay of the land. So thank you for your patience with the court. Court appreciates that. Nothing personal, so you can take it from that. Likewise, Mr. Berger, thank you for your patience with the court. You had to repeat yourself, but that's because I just had to test some of the submissions that they had made also, and to fully ventilate that. So thank you all for your patience with the court, the heads of argument. For those who prepared the record, the attorneys, thank you very much for that. It helps when the record is